The USMCA was supposed to be bulletproof. It replaced NAFTA in 2020 with full American approval, full Canadian approval, and years of legal work behind it. Then, in one executive action, Trump rendered it meaningless for hundreds of Canadian goods. The tool he used wasn't new legislation, wasn't a court order, and wasn't even a negotiation. It was a law written in 1930, named after two politicians most Canadians have never heard of. That law is the Smoot-Hawley Tariff Act, and Section 338 is buried deep inside it. If you want to understand where North American trade is heading, this channel is your signal. Subscribe to Capital Current right now, because this story is still unfolding as we speak. On July 20th, 2026, President Trump signed 3 presidential proclamations in a single afternoon. Each one invoked Section 338 of the Tariff Act of 1930, a provision dormant since the late 1940s. The result, an additional 50% tariff on roughly $20 billion of Canadian goods. That figure represents about 5% of everything Canada ships into the United States every year. The goods hit include motor vehicles, alcoholic beverages, dairy products, machinery, and far more. Hundreds of product lines were swept up, from auto parts to hockey sticks. And here's the detail that made trade lawyers across North America stop cold. These tariffs apply even to goods that fully qualify under USMCA. USMCA certification, which Canadian exporters have leaned on since July 2020, offers zero protection here. That matters enormously because USMCA was built specifically to prevent this exact scenario. For 6 years, compliant Canadian goods entered the United States largely duty-free under that deal. Section 338 just overrode the entire framework without renegotiating a single line of the agreement. To understand why this is seismic, you need to understand what Smoot-Hawley actually was. Congress passed it in 1930 as the Great Depression tightened its grip on America. Senator Reed Smoot of Utah and Congressman Willis Hawley of Oregon pushed the bill through. The goal was to wall off American industry from foreign competition during the collapse. It backfired catastrophically. Other countries retaliated. Global trade seized up, and the depression deepened. Economists still cite Smoot-Hawley as the textbook example of protectionism gone wrong. Section 338 was a narrow clause tucked inside that law to handle discrimination against American exports. If a foreign country treated American goods worse than goods from any other nation, the president could respond. The response was simple: a unilateral tariff increase. No congressional vote, no investigation required, no time limit. That last part matters enormously. Section 122, another tariff tool Trump used earlier, expires after 150 days. Section 338 carries no expiration date at all. Once imposed, it stays until the president chooses to remove it. Between the 1930s and the 1940s, the provision was referenced a handful of times in diplomatic correspondence. After 1949, it went silent. No president touched it. No administration even mentioned it publicly. That silence lasted nearly 80 years, while the entire global trading system was rebuilt around it. The WTO, NAFTA, and then USMCA all rose up, while Section 338 sat untouched on the shelf. Then the Supreme Court changed everything. On February 20th, 2026, in a 6-3 ruling, the justices acted. The case was Learning Resources, Inc. versus Trump, and the decision was direct and sweeping. The court held that IEEPA, the International Emergency Economic Powers Act of 1977 does not authorize tariffs at all. Every tariff Trump had imposed on Canada and dozens of other nations under IEEPA was immediately invalidated. That included the 25% tariff on most Canadian goods from early 2025 and the so-called Liberation Day tariffs applied worldwide that April. Billions of dollars in duties suddenly had no legal foundation, and the administration needed a new tool fast. What happened next was one of the most aggressive pieces of legal archaeology in modern trade history. Administration lawyers went digging through decades of dormant statutes for something the courts hadn't touched yet. They found Section 338. No modern precedent, no procedural requirements, no time ceiling. It requires no investigation by the U.S. Trade Representative before the President acts. It requires no formal national security determination, unlike Section 232 of the Trade Expansion Act of 1962. It requires no congressional consultation before signing, and no report to Congress afterward. The president simply issues a proclamation, and 30 days later, the tariffs take effect automatically. Compare that to Section 301, which requires a formal USTR investigation that can drag on for months. Section 232 requires the Commerce Department to produce a full national security report before any action. Section 338 skips all of it. It is the fastest tariff mechanism in the entire American legal arsenal, and that's exactly why the administration reached for it the moment IEEPA was struck down. The three proclamations each targeted a distinct Canadian sector. The first hit the automotive sector, citing Canada's 2025 surtax on American-made vehicles. Canada had imposed a 25% tariff exclusively on U.S. origin motor vehicles starting in April 2025, while vehicles from Japan, Germany, South Korea, and Mexico faced no such tariff. Under Section 338's logic, that asymmetry counts as discrimination and triggers presidential authority. Canadian imports of U.S. motor vehicles fell by roughly 22%, or about $5.6 billion, over the following year. The second proclamation targeted alcoholic beverages, and this story is worth slowing down for. When Trump's first round of tariffs hit Canada in early 2025, provincial liquor boards responded fast. Ontario, British Columbia, Quebec, and others pulled American spirits and wine off government store shelves starting that March. Over the following year, Canadian imports of U.S. alcoholic beverages dropped by roughly 81%, close to $600 million in lost American sales, while Canadian imports of spirits from Japan, Ireland, and Argentina climbed. Section 338 saw that clearly. American products were being treated worse than products from every other country. The third proclamation targeted dairy, specifically how Canada administers cheese tariff rate quotas across competing trade deals. Under USMCA, American dairy producers get quota access to the Canadian cheese market, with specific limits attached. Under Canada's separate trade deal with the European Union, CETA, European retailers can access and use quota quantities more freely. American retailers under USMCA can't access the same quota the same way. The administration argues this gives European dairy producers a structural edge inside Canadian markets that American producers don't get. Each proclamation imposes a uniform 50% additional tariff on its own basket of goods, taking effect at 12 a.m. Eastern Time on August 19, 2026. Covered goods span roughly 554 Canadian tariff lines, reaching far past autos, alcohol, and dairy. Wood products, paper, textiles, machinery, electronics, cement, even hockey sticks, all landed inside the annexes. From August 19th, the duty covers close to $18 billion of Canadian goods at the full 50% rate, with USMCA certification offering no relief whatsoever. Now here's what Canada found when it looked closely at the legal architecture Trump just deployed. The first question Canadian trade lawyers flagged: does Section 338 even legally exist anymore? Philip Zelikow, an emeritus professor at the University of Virginia, who worked on the earlier IEEPA litigation, argues Section 338 was effectively superseded, first in 1962 by the Trade Expansion Act, then again in 1974 by Section 301 of the Trade Act. His argument is straightforward. When Congress builds a detailed new system to govern something, it implicitly displaces the older, cruder mechanism it replaced. Section 338 is that older mechanism, and it has never once been tested in a modern court. The Supreme Court's IEEPA ruling turned on the same basic idea, that the president can't claim unbounded tariff power without clear congressional authorization. Whether that reasoning stretches to cover Section 338 is now the central open question in this fight. The second thing Canada's negotiators immediately clocked was the narrow, specific nature of Trump's three grievances. Two of the three involve Canadian retaliatory actions that could simply be reversed: the auto surtax and the provincial alcohol restrictions. The dairy issue is a narrower tariff rate quota eligibility problem that's arguably addressable inside the USMCA review itself. Canada didn't invent discrimination out of thin air. Canada retaliated against American tariffs that came first. That sequencing matters enormously in any legal challenge before the U.S. Court of International Trade, because Section 338 was designed to answer unprovoked foreign discrimination, not retaliation that America's own actions triggered. For 4 decades, U.S.-Canada trade disputes followed the same script. Washington imposed duties, Ottawa retaliated. Canada challenged under NAFTA, the WTO, or USMCA. Lawyers argued, politicians settled, and the cycle repeated. This time, the administration is rewriting that script with a statute that predates every one of those institutions. As Washington has taken a harder line with allies, Canada has been quietly plotting an economic path that doesn't run through its southern neighbor. In January 2026, Prime Minister Mark Carney made a state visit to Beijing, the first by a Canadian Prime Minister since 2017, and Canada and China reached a preliminary trade agreement during that trip. In July 2026, Ontario and Alberta proposed a new oil pipeline between the two provinces, designed to bypass the United States entirely. The existing Line 5 crosses through Michigan, giving Washington real leverage over Canadian energy exports. A coast-to-coast pipeline would let Canadian oil reach Atlantic terminals and ship directly to European buyers. None of this is coincidence. It's Canada's long-term answer to an increasingly unpredictable American relationship. Ottawa's dilemma right now is one of the most delicate balancing acts in modern Canadian political history. If Canada retaliates further, Section 338 itself hands Washington the legal authority to escalate again. The statute doesn't stop at 50%. If a country keeps discriminating after a Section 338 tariff lands, the president can escalate to a complete import ban, with no statutory time limit. That option is sitting on the table in Washington right now, fully loaded. Ontario Premier Doug Ford has publicly called for dollar-for-dollar retaliation if talks with Washington collapse. But the domestic politics that reward firmness run straight into Section 338's escalation trap. Every time Canada retaliates, it hands Washington a fresh legal argument for the next proclamation. That's the snare the statute sets. Canada is expected to pursue 3 tracks at once: a calibrated response, formal dispute settlement, and a harder push at the USMCA negotiating table. Prime Minister Carney has said publicly that Canada stands ready to engage intensively with Washington. USTR Ambassador Jameson Greer told the Senate that talks with Canada haven't been cut off. But the 30-day window before August 19th isn't just a diplomatic timeline. It's an ultimatum with a price tag attached. The White House has left the door open. If Canada drops its remaining retaliatory measures, including the 25% tariff on U.S. vehicles and roughly $15.6 billion in steel and aluminum tariffs, the proclamations could still be reversed before the effective date. Washington isn't asking Canada to do something new. It's asking Canada to undo what started with American tariffs first. And that sequencing argument is Canada's strongest card in any legal challenge at the Court of International Trade. Now layer on the single most important trade development that happened just 3 weeks before all this. On July 1st, 2026, the USMCA Free Trade Commission held its mandatory 6-year joint review under Article 34.7 of the agreement, and the United States declined to confirm it would extend the deal for another 16-year term, stating it did not agree to renew USMCA in its current form. Mexico and Canada both confirmed their support for extending it. The United States refused, alone. That triggers an annual joint review process that will run every year until the parties agree to an extension or the agreement expires on July 1st, 2036. The most important trade deal in North American history is now sitting inside a 10-year countdown clock. Every Canadian company with cross-border supply chains is operating inside that window right now. USMCA covers well over $1 trillion in annual trade among the 3 countries. Section 338, tariffs landing 3 weeks after USMCA non-renewal, is not a coincidence. It's leverage. Washington is using a 96-year-old law to pressure a renegotiation of a modern trade deal on American terms, and possibly to pursue separate bilateral concessions from Canada specifically. Here's what makes this genuinely dangerous for the whole North American economic architecture. Because Section 338 requires no investigation and no comment period. Tariff changes can appear with as little as 30 days' notice, and the President can amend or escalate to a full import ban at any time. Supply chains that took decades to build can now be disrupted in a month with zero procedural warning, and the threat sharply escalates tensions, regardless of whether the tariffs are ultimately imposed. Because businesses relying on USMCA protections now have to plan for the possibility that those protections simply don't apply. Let's talk about what this actually means if you're a Canadian business owner, not just a headline reader. If you export vehicles, auto parts, dairy, wine, or spirits into the United States, you need to check right now whether your product lines fall inside one of those 554 tariff codes, because USMCA paperwork will not save you this time. If you import American inputs for a product you re-export, your landed costs could shift overnight on August 19th, regardless of what your contracts assumed 3 months ago. Freight forwarders and customs brokers across Ontario and Quebec are already fielding a wave of calls from manufacturers trying to model worst-case scenarios before the deadline hits. And if you sit on either side of the border with inventory in transit, the timing of that midnight cutoff on August 19th is not a minor detail. It is the exact line between the old rate and the new one. There's also a political dimension Canadians shouldn't overlook. Every time this fight escalates, it becomes harder for either government to back down without looking like it folded. Carney's government came into this year promising to stand firm against unpredictable American trade pressure, and provincial premiers like Ford have staked real political capital on retaliation rhetoric. Trump's administration, meanwhile, is framing Section 338 as correcting decades of unfair treatment, a message that plays well domestically, regardless of the legal uncertainty underneath it. That combination, firm public positions on both sides, layered onto a genuinely untested statute, is exactly the kind of situation where miscalculation becomes more likely, not less. This is no longer just a Canada problem. Section 338 is a global template if it survives a legal challenge. If it does, it could be deployed against the European Union, China, Japan, or any other trading partner, representing a real expansion of unilateral presidential tariff power. Every trade agreement America has ever signed could face the same override from the same 96-year-old statute. The WTO, bilateral deals, multilateral frameworks, none of them were built to account for Smoot-Hawley's Section 338 coming back from the dead. That's the real weight of what happened on July 20th, 2026, and why markets need to be paying attention right now. The Canadian dollar, already under pressure through 2025, faces continued downward pressure as this uncertainty compounds. North American auto manufacturers with integrated cross-border supply chains face immediate landed cost recalculations. Companies importing Canadian dairy, alcohol, wood products, furniture, or machinery need to rerun their numbers before August 19th. Scroll past the headline categories and the list broadens fast. Wine, hockey sticks, cement, plywood, furniture, fishing rods, seeds, clothing, and swimming pools are all caught inside the tariff annexes. Businesses that thought they were safe because they only read the headlines are carrying the largest surprise exposure right now. The story of Section 338 isn't just about Canada and the United States trading tariff blows. It's about the slow erosion of a rules-based trade order that took 70 years to build. When a 96-year-old law can override a modern trade agreement signed just 6 years ago, the whole system is exposed. USMCA was supposed to be the foundation of North American trade for a generation. Right now, it's on annual review, partially bypassed, and sitting inside the most uncertain trade environment in decades. For everyday Canadians, none of this stays abstract for long. Tariffs on autos and auto parts tend to work their way into sticker prices within a couple of model years, since manufacturers rarely absorb a 50% tariff on their own margins. Dairy and alcohol tariffs move faster, showing up in shelf prices or availability within months rather than years, especially for smaller Canadian producers exporting a meaningful share of volume south of the border. Layer a weaker Canadian dollar on top of that, and imported American goods get pricier here too, which is its own quiet tax on households already dealing with years of elevated costs. None of this guarantees a recession on its own, but it does mean the next 12 months of grocery bills, car prices, and cross-border shopping trips are now tied in part to how a 96-year-old statute gets interpreted by courts that have never had to rule on it. Canada found what stopped Trump's first legal tool. The Supreme Court killed IEEPA in February 2026 conclusively. But Section 338 is a different statute, a different legal theory, and a fight with a genuinely uncertain outcome. The 30-day window closes on August 19th. What happens next will shape North American trade for years. If you want to stay ahead of every move in this story, hit subscribe to Capital Current right now. Drop a comment below and tell us, should Canada retaliate or hold the line and negotiate? Every signal matters in a market like this one, and that's exactly why this channel exists.